Hafa and welcome everyone to the Guam Congress building. The Committee on Health, Land, Justice, and Culture is now called to order. Today's Monday, July 18, 2022, and it's about 1:35 p.m. My apologies for starting late. Our last hearing ran late, and there are some setup that we need to do in between. So in compliance with the open government law, notices for this hearing were published in the Guam Daily Post on Monday, July 11 and Friday, July 15. The notices were posted to the Government of Guam public notice portal, and this hearing is live streamed via the Guam Legislature's YouTube channel. Notices were also disseminated via email to all senators and all main media broadcasting outlets. The general rule of conduct that if you could please help us with just introducing yourself when you're going to speak so that for record, our records are clear because we transcribe the audio versions of these. Please wait until you're recognized by the chair before speaking. There are 3 agenda items for this public hearing. Bill number 317-36 COR, introduced by Therese Terlaje. This is an act to amend 12212.1 of Article 2, Chapter 12, Title 10, Guam Code Annotated, relative to public disclosure of physician profiles. The bill adds an additional, well, we're going to introduce that bill in detail soon, bill number 317. And the second item on our agenda today is Bill number 318-36 COR, also introduced by Therese Terlaje, an act to amend 12203A of Article 2, Chapter 12, Title 10, Guam Code Annotated, relative to the composition of the Guam Board of Medical Examiners. And Bill number 319-36 COR, introduced by Therese Terlaje and Terlaje, which is an act to add a new Chapter 42C to Division 3, Title 7, Guam Code Annotated, relative to implementing the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021 into Guam law. And that is a federal law that we are trying to enact into Guam law. I want to acknowledge and thank my colleagues for being present today, beginning with the Minority Leader, Senator Chris Duenas. Thank you for being here. Senator Tony Ada. Thank you, Senator. We're also joined today by my Vice Chair on Committee on Health, Senator Therese, who will be back in shortly. I know she's in the hall, and Senator Joanne Brown. All right, I'm going to just, we're going to start with the hearing on Bill 317, but there's several testimonies that tie the 3 bills in together and testify together, so I just want to, for the listening public, just to know generally what the other 2 bills do. So the second bill on our agenda, it proposes to change the composition of the Medical Licensing Board, which is currently 6 of the 7 members shall be physicians, to change it to 5 of the 7 members shall be physicians. So that adds an additional civilian or non-physician person on that board. The other thing that it does is sets the term for 3 years. There were different term lengths, and we want it to be consistent, but and we will discuss this later, but it also sets a term for all appointed members to 3 years. And then it limits service to 2 consecutive full terms. All right, that's Bill 318. Bill 319 models, there's a federal act that was passed by Congress, enacted into law, that ends forced arbitration of sexual assault and sexual harassment. So some employers and some entities require arbitration for any dispute. But this congressional law, which does not apply to Guam, would make an exception to those forced arbitration agreements, and saying that if it is a case of sexual assault or sexual harassment, then they were not bound to go through forced arbitration, that they had other avenues. And so our attempt by this bill is just to extend those provisions to Guam as well. All right, so on Bill 317, I'm the sponsor, so I will introduce the bill. So this section of the code that this bill proposes to change is called the Public Disclosure of a Physician Profile. This was a law passed prior to my even serving as a senator, which has been 5.5 years now. So prior to that, there was a law passed requiring public disclosure of a physician profile, and this law lists specifically what information should be posted by the Guam Board of Medical Examiners on its website for patients to see, or potential patients to see, so that they could make an informed decision. Some of that information includes whether or not the licensee is presently in good standing, the American Board of Medical Specialties certification or equivalent as certified by the board, whether there is a temporary restraining order, interim suspension order, revocation, suspension, probation, or limitation on practice ordered by the board or the board of another state or jurisdiction, including those made part of a probationary order or stipulated agreement. Current accusations filed by the Attorney General, including those accusations that are on appeal. Current actions meaning an accusation that has not been dismissed, withdrawn, or settled, and has not been finally decided upon by the board, unless an appeal of that decision is pending. And citations issued that have not been resolved or appealed within 30 days. All right, that's the current status of the law. So my bill proposes to add the following language to that list. Current accusations filed and pending with the board, so pretty much by anyone, pending with the board for more than 6 months, including those accusations that are on appeal. For purposes of this paragraph, current accusation means an accusation that has not been dismissed, withdrawn, or settled, and has not been finally decided upon by the board. And this bill is intended to just improve the access to patients of this type of information so that they can be informed and make their decisions as to which doctor they will see or whether some of their concerns might have also been brought up by someone else. And it's limited. Not every claim, according to this bill, would be published. Only claims that have not been dismissed, withdrawn, or settled, or finally decided upon by the board within 6 months. So in addition to informing patients, the goal also is to put a little fire under the board to resolve these claims. And because some of these claims, we've had several oversight hearings, and we found that some of these claims have not been settled, and some of them for years. And we have tried to resolve many of the issues that the board faced, and we have different members of the board revolving as well. But some of these issues started with financing, and we've tried to make it very clear, since I became chair of the Committee on Health, that the boards, each health board, we have a medical licensing, a nurse licensing, dental licensing, allied health licensing, other boards as well. But each of these boards are supposed to control their own finances. They implement the fees, and they have the control of increasing their fees. And all those fees are supposed to be used for the board's purposes. Some of these fees currently get used for HPLO staff, but they've also been used, and recently, finally, they were able to be used to hire attorneys to act as a public hearing officer so that they can actually have hearings on complaints. They've used their money as well to hire an attorney to act as a prosecutor in the cases, and they are currently also assisted by the Attorney General's office as an advisor to the board, or counsel to the board, and to the HPLO office. So since the mandate of the public disclosure of physician profiles has been placed into the Guam law, GBME's compliance, it has actually taken a while for this to become manifested, to be published, but it is published now, and I want to thank the board, the recent board, and their efforts. It's only recently that that's been accomplished. So thank you to the board and to the HPLO staff in getting these profiles published after actually, I think that year, trying to remember the year that law was passed. I'm sorry, I don't have it in front of me, but it's been several years. And again, at least 5, I think maybe 8 or more. So finally, the physician profiles are published. They're not up to date. We found out at our last oversight hearing, they're not up to date. And a lot of effort has been made by the HPLO office to input data into those profiles to continue to update them. We learned that in the February 16th oversight hearing that out of 600 active physicians on island, the GBME has only 50 physician profiles available for public view on the website. The website, however, did not indicate active complaints under investigation nor determinations made by the board in closed cases. The only information is the doctor's license status and number. So at that time, the Committee on Health reviewed the minutes from past GBME meetings and noted several active complaints against doctors, all of which were still pending resolution. We heard from individuals who had filed complaints with GBME against licensed doctors in Guam. Some complaints involved doctors with past records of misconduct, to include sexual assault, and they all expressed the sentiment that had information on the doctor's past records been available, they could have made an informed decision when choosing physician care. Also during that hearing, the GBME, the chairperson, had insisted that the board does not license doctors who are under active investigation or have had their licenses revoked in other jurisdictions. So Bill 317 was introduced, again, to mandate that the posting of current accusations filed not just by the Attorney General, but by others, including those accusations that are on appeal, be posted as well to the physician profiles. And this is to be done only if they are not resolved within 6 months. In addition to the stakeholders, invitations to provide feedback were sent to the following: the Department of Public Health and Social Services Health Professional Licensing Office, which I refer to as HPLO. I don't think there's a representative from HPLO here today. I don't see one. The Guam Board of Medical Examiners and the members of the Guam Medical Society and the Guam Medical Association. I want to thank those of you who are present. Phil Flores is a member of the Guam Board of Medical Examiners for many years now, and Dr. Annette David, who's also one of the newer, more recent members of the Guam Board of Medical Examiners. Thank you very much for being here. We also have members of the public who are here to testify. The committee is in receipt of written testimony on Bill 317-36 COR from the following: Mr. David Lebowski, who's also here in person to testify, Ms. Annalyn Lagrimas, Ms. Danielle Baza, Mr. Franklin Meno, Ms. Bistra Mendiola, Dwayne Sinicolas, Jonathan Savares, Dr. Blounce, Sandra Siao, and a joint testimony from the Guam Medical Association and the Guam Medical Society, GMA and GMS. The BBMR has reviewed this bill and determined that it is administrative in nature and poses no fiscal impact upon any of the funds of the government of Guam. We had, prior to introducing this bill, sent an inquiry to the AG's office and to the Guam Board of Medical Examiners Council separately, inquiring whether the current statute requires publication of these complaints already. We sent a follow, that was on May 25th. We sent a follow-up on June 15th to both, and we have received no responses to date. So it's our reading that it does not mandate publication of anyone else's complaints except those filed by the Attorney General. And that's why we are proceeding with this bill. All right, I'm going to now allow those who've signed up to testify to testify. Oh, you didn't sign it. Okay, I'll begin with Mr. Lebowski and then Dr. David. I know, Mr. Flores, you were here. I think you failed to sign in, but I'm going to add you after Dr. David, the two members of the board. I cannot read this name. But I've got Maria Espinosa and Robin Marquardt. There's another name here. Are we missing someone? Oh, that's Phil? Sorry, that is you. Okay, I just couldn't read it. My fault. My fault. Okay, my apologies. All right, so let's begin. Mr. Lebowski.
Okay. My name is David Lebowski. Thank you, Speaker Terlaje and Senators, for allowing me to submit testimony regarding Bill 317-36. I am, of course, in support of this bill and its intended amendments for the further protection of medical consumers on Guam. We live on a closed medical island, meaning all medical decisions apparently are decided by a select group of doctors and their supporters and channeled through the Guam Board of Medical Examiners, who does not have public confidence. Off-island specialist doctors who want to set up shop on Guam are deterred from doing so due to local doctors on Guam who do not have specialist skills but still do these specialist procedures as they are protected by local law. This would be called malpractice anywhere else, as stated by Attorney Kao during the Bill 112-36 hearings. Specialist doctors, real specialists from off-island, must compete with non-specialist doctors who reside on Guam to set up shop, making it near impossible to recruit these doctors, making it near impossible to improve medical care on Guam. Without getting into this further, and the discussion and related reasons for poor medical care on Guam to this issue and a lack of medical accountability on Guam, it's fair to say that medical consumers, our families, our loved ones, our kids, our children, have to be proactive to know who to see or not to see in terms of doctors, including their skills, histories, allegations of malpractice, sexual misconduct, medical negligence, etc. Bill 317-36 refines the current legal requirements of the web page. And by the way, the current web page doesn't list doctors who settle wrongful death, who have wrongful death settlements. They're not listed on the webpage. It's not required by law. The current webpage is required by law, and the medical exam is to more adequately meet the needs of consumers. Consumers are stuck having to rely on their own research as to whom to see medically, especially since the lack of accountability and transparency has kept negligent doctors cloaked from the public. The Guam Board of Medical Examiners has a document history. I'm not making this up, it's in the newspaper. There's a document history of licensing doctors with medical negligence or sexual misconduct histories. Then bringing these doctors to Guam where the sins of their known past actions are repeated on unsuspecting Guam residents, resulting in negative lifelong impact or worse damage. Bill 317 will offer any consumer on Guam the opportunity to have a much clearer look at the profiles of medical professionals who treat them or their loved ones. With Bill 317, there will be less hiding of medical negligence to protect doctors and more protection afforded to the people of Guam. Just a reminder, it has been around 10 years since the board was required to provide profiles of doctors. They didn't start to do it until recently due to a public outcry and some oversight meetings. It has also been more than 5 years since the board was required to provide a profile website, but again, it was not done until recent public outcry. Let me remind you, for those that do not know, that the chair of the Guam Board of Medical Examiners, Nathaniel Berg, publicly, very recently, has said that he did not want to set up such a website, even though he knows it is the law. He found fault with the Speaker and the legislature inappropriately for forcing him and the board, in essence, to help consumers by providing doctor profiles on such a website. I interpret this again as he and the board want to protect their colleagues more so than the medical consumers on Guam, which conflicts with the board's own mission. Also, let me inform you or remind you, under the current medical board, under Nathaniel Berg's leadership, there has never, ever been a case decided for a victim claimant. Never, not one. And we're talking about maybe around 45 cases now. Statistically, nationally, it's impossible. It shows protection of doctors rather than protection of consumers. In my opinion, the most important part of Bill 13 is regarding current accusations. The way it is now, doctors who are accused of doing serious harm to patients, sexual misconduct, killing somebody, are allowed to practice for years, often with no accountability, no mitigation, but also without other patients knowing what they did. It's a hidden secret. No, you cannot know that. Virtually, this is going to sound weird, but it's true. Virtually, a doctor can kill 3 people in a week through medical negligence, and no one will know it as things are set up now. Sad. Doesn't the father of a teenage girl have the right to know if his child's doctor has been accused of sexual misconduct? My gosh, think about it. If that was your daughter who was the victim, you would freak out, especially when you learn that the board has knowingly prevented the information from public access. Doesn't the mother of a young child have the right to know that her pediatrician was accused of killing a child through medical negligence? Enough with hiding these crimes from the people of Guam, who again have no resolution for medical negligence. The current message is clear from the board and from the medical community. The current message is this: hey, sorry, your daughter was killed by a pediatrician who we knew did similar negligence in the past. But we licensed him anyways and didn't want to tell anybody, but just suck it up, as we have arbitration to protect us, and we don't have to put it on our website. And if you complain, you'll lose medical services, which has happened. I'm not going to talk about my son. I'm talking about tomorrow, the next individual, because it happens daily. We see all the time in the newspaper about medical negligence, somebody else suffering from it, and people just wash their hands and walk away. But I will say, it's been 4 years since my son has passed away. The complaint in front of the Guam Board of Medical Examiners has been sitting there for 2 years. They have done pretty much nothing, and they have reports from off island for the last 6 months, nothing's happening. There's no reason for that, while the doctors continue to practice in the community. So accusations are very important when doctors continue to practice. Let's get it finalized, and please, please pass Bill 317. It's all about, in my opinion, greed versus consumer protection. Thank you.
Thank you, Mr. Lubofsky. Dr. Annette David.
Thank you, Madam Speaker. Good afternoon, buenas yan, half a day to our senators. I've actually just arrived back on island, so I haven't had the chance to prepare written testimony, but I thought this was very important. So I come here as an individual member of the board, not having spoken to any of the other board members about this, and speaking from the heart. I was thinking of talking about both bills combined, but since we're doing this first one, I think what I wanted to say here is that as a naturalized US citizen, I was always taught that in America, under a democracy, you are always presumed innocent until proven guilty. And an accusation is not a conviction. I think there are ramifications to this proposed addition that need careful thought. Because in truth, yes, there are some cases that are serious, and that information needs to be out there once a decision has been reached. It is important for patients to have access to this information, but accusations in and of themselves are not proof of guilt. And I would ask if there is any other group of professionals who hold positions of public trust who are being held to the same standard of having to report every accusation brought against them publicly. Do we do this for the other health professionals that have their own boards? Do we do this and require this for lawyers who also hold positions of trust? And in fact, do we do this for elected officials who hold positions of trust? Do we mandate publication of any and all accusations before they are completely investigated and shown to be true or false? So I think this is an important consideration that needs to come in. And I would say that I do not support this current proposed addition to the law. I think the second is not so much in terms of, in a sense, if you apply the standard only to health professionals who are physicians as a class, I guess that would constitute discrimination as I understand it. And so there is that ethical issue. The second issue is an operational issue. It's not easy to make sure that all the information required is, number one, verified, because you do not want to publish anything publicly on physicians that is not verified. That could be very harmful to that individual as well. And the burden of data entry, too. Members of the board are all volunteers. We are provided administrative support by the HPLO, but please keep in mind the HPLO staff, very small and very efficient as they are, have to provide support to the 8 other boards that exist. And at the time of COVID, some of them were pulled to do double duty. So I think if we want to see faster reports, faster data that are entered and published online, then I think we need to make provisions for that sort of support, data verification, data entry support for the boards. I think I'll stop there for this bill, but I do have some inputs and suggestions for the next bill. Thank you, Madam Speaker.
Thank you very much, Dr. David. Mr. Phil Flores.
Okay, all right. Honorable Speaker, Senators, I also have testimony on 2 bills, so I'll just do I'll just read the portion here that addresses 317. Okay. I currently serve as the public member of the GBME. I joined the board in 2015. Today I'm representing myself only, that is, I am not representing a formal position of the board. The board cannot take a formal position on the bill without holding a properly noticed public meeting. We meet monthly. Our most recent meeting was held last month on June 8th. Our next meeting is this Wednesday, July 20th. We will address, however, in accordance with Public Law 3634, we are not permitted to discuss the bills on Wednesday because we had already published our agenda when we received the notice of an invitation to the hearings today. We will address them in our August meeting, which is scheduled for the 10th, and we invite you, Madam Speaker, and Senators to attend. You can't hear this because it goes to my hearing aids. But his phone ringing. Okay, with respect to 317, I am personally in opposition to the amendment. You are asking that accusations be published prior to them being proven, and would be opening the door to possible libel and defamation suits against GBME board members and HPL administration and staff members, if and when a complaint is not held in favor of the complainant. Guam law does not protect them, them being the board members and the staff and administration, from a civil rights lawsuit filed in federal court for violating the physician's civil rights. It is very difficult to find people to just sit on about any board in the government. This would make it harder for recruiting GBME members. I do not believe that accusations should be posted until the case is settled, and then only if in favor of the physician. Okay. I'll save 318 for the next one.
Thank you. Maria Espinosa.
Yes, good afternoon, Speaker Terlaje. My name is Maria P. Espinoza, and I'm in support of Bill 317. I don't have a written testimony, but I've got down notes to keep me on track. Okay, I actually went to the Guam Medical Board website, and I thought that the very, very extreme skeletal kind of information was just not satisfactory. I thought that we should be able to get some more information about the various physicians on the island. And definitely on line subsection capital F, the accusation is defined as filed and pending with the board for more than 6 months, including those accusations that are on appeal. This will help to, in layman's terms, kick the board to take action and do their research and make a determination for the benefit of the physician as well as for the patient who has filed grievances. Okay. And in their website, I found an Article 6. I believe I was having such great difficulty printing out any material. So I'm pretty sure it was Article 6, and that Section 3 says, reporting possible violations to the board. And letter A, capital A, says voluntary reporting. Any person may report in writing to the board any information that he or she has reason to believe indicates that a medical licensee is or may be medically incompetent, guilty of unprofessional conduct, or mentally or physically unable to engage safely in the practice of medicine, or that another violation of the Physicians Practice Act or the rules and regulations of the board has occurred. That's the voluntary that refers to me and any other person that feels strongly against physician. But capital B is the compulsory reporting. And there's a listing of the following persons and entities are required to report promptly in writing to the board any information that indicates a medical licensee is or may be incompetent, guilty of unprofessional conduct. Continue on with those same things. And there's a list of 8. So all physicians licensed under the Physicians Practice Act are mandated to do reporting under those premises. The second group, all other healthcare providers licensed in Guam. Number 3, the Guam Medical Society and its components. Number 4, all hospitals and other healthcare institutions in Guam. Number 5, all state agencies are mandated to do this reporting. 6, all law enforcement agencies in Guam. 7, all courts in Guam. 8, all peer review bodies in Guam. And it continues on with more information, but with all of there are a lot of people that are mandated to report incompetencies, and as well as the public at large. And the reason why I bring this up is the problem is, and I did read Mr. Lebowski's testimony, that even myself, having given over the years, 8 years that I took care of my son, I did actually write 2 letters to the GMH administration of, the first one was related to charges and stuff, but the second one was complete, I can't even think of the word, I get so upset. This doctor was so unprofessional. I literally told her, get out and don't you dare touch my son. She came in there, not even with her 4 sentences. It was very clear to me she did not even read his diagnosis. And on top of it, she told me that because I probably had this and that disease that she presumed I had, that is why my son, it was the way he was. Complete. And so I told her to get out and don't you dare touch my son. And I went within less than 24 hours. There were so few sentences, and she was laying that we're spending $100,000 on antibiotics on your son, blah, blah, blah. Like, she was telling me that he was not worth all the money and time spent on him. And so there were so few sentences. I remembered verbatim what she said, what I said, put it up in like a script for a screenplay, typed it up, and made an appointment to speak with the director. I was given the deputy, the titles are, I don't know. Anyway, the number 2 person at GMH at the time with the lead nurse. And they told me they were happy that I took the time to type out this grievance and that they would discuss it and what did I want to do about it. Well, as bad as she was, I did not know exactly what her role in the hospital was. I wanted that there would be an investigation to see if any other patients' families or the patients themselves made any reports. That's what I asked them. And if there were more than my report, that they would, lay it on her and let her know that that's not, those behaviors are not appropriate. And so I made that letter in December 26, 2019, and I had a very short response here, which I've been very pleased. The hospital is obligated to respond to your grievances. I don't remember, it was at least 2 weeks, if not 1 month, but they sent me a response letter January 14. And so we monitor the care provided to our patients. Okay, after reviewing your letter, our medical director met with this doctor and your issues were discussed and addressed. The medical director also reviewed your son's records and they apologized. But they were glad that I reported her. But the problem here is, even though I made this letter, I didn't really understand the extent of what I could do with this very grave issue that I brought up. And if you look at I got a copy from the hospital of their policy and procedure, but it's a very simple updated version. The patient writes, it says here it's the abbreviated version. And there's a line item under the general category, number 29. It says, file a grievance/complaint, and to be informed of the process to review and resolve the grievance or complaint. These are categorized under the general category. So I did file it, but there was no real explanation of what I could do. And I think every person, every patient should have a chart when they're referring to grievances. If you feel strongly about it, write a letter. You know, a chart, add it on to their grievance procedure and say, whatever it is, make your complaint. I usually go to the patient affairs lady. She's very good. I don't know if she's still working or has retired. But you go to her, and she always follows up. But this thing, I wrote it up myself, made an appointment. So there should be a chart. What can you do? Because you never know. You don't expect to go to the hospital thinking that you're going to come out with your child dead or what. You go there for better health, right? But in case something does happen, and you have observed, and I've learned quickly on to bring a notebook and make notes left and right. Because my son does not speak. He didn't know how to talk. I'm sorry, he's passed away. And that's the problem here. I see it. I approve the bill. I support the bill. But there needs to be that information of what you can do with your very grave complaint, serious complaint. And you don't really understand it. You know, the Guam Memorial Hospital has a board, but you know, how do you proceed? Protocol is extremely important. I've learned early on in my adult life, and if you don't follow protocol, nothing gets done. You got to put it down in writing, and people need to understand how to get it done. It's the same. I have a copy here of the half-a-day specialist that my husband goes to, and it's just a two-liner. Patients have the right to discuss concerns or file formal grievances or complaints about their medical care and treatment. But according to the board's requirement, Article 6, subsection, as I read it earlier, Section 3, voluntary reporting, any person may report in writing to the board any information, right? So how do we get to that point? We don't know that there's a board of physicians. And if we're not happy with what's going on at the hospital or various clinic, because according to this list, the whole hospital and other healthcare institutions in Guam are mandated to make a report, all state agencies. We don't know about that. How do we know that? Until we have the experience of being in the hospital or a clinic that did something that we don't approve. We need to have something to bridge between the institution and the board. And just a quick, the most serious was when my son first came down. He went in there for the general dental work under general anesthesia, only because he cannot communicate and he cannot sit still long enough to do everything. And what happened, they put him to sleep on the operating table. In less than half an hour, he was not getting the oxygen he had. He died on the table. Well, that was very serious, and when we finally got together with the anesthesiologist maybe 10 days later, she explained that she could not understand why he was getting on oxygen, and all she said was, someone must have dislodged the oxygen tube. And then she said, people make mistakes. They die on the table, and that's okay? I mean, that's serious to have somebody die on the table within a half an hour. And so how do we know to get to the board? I feel that at that point in time, I should have been able to go to the board with my complaint. And even when I tried to get a lawyer, nobody wanted to take him. I couldn't sue anybody because, as you know, the mandatory mediation just is overwhelming. But it wasn't even that. No lawyer wanted to take him. And so with that, thank you for giving me I'm sorry I'm a little emotional, but it's very important that it says here, for more than 6 months, if this accusation has not been dealt with, and that's certainly sufficient time for medical causes. We're not talking about somebody with petty theft or even breaking and entering. This is a person's life. I've always felt as a teacher that we work hard, more hours than we're paid for. When it comes to medicine, they are really very critical. We value all the work that they do, and we entrust our family to them. And if there are any physicians who have taken for granted of the kind of laxed attitude towards the lax behavior, they need to get their names posted on their website. And right now, I looked at the website, and it's basically little to nothing to say about any one of them. I didn't know that I could myself go to the board with my complaint. We need to get a bridge in there, and although we're not here to mandate the bridge work, but the work won't be finished even after this bill, if approved and made into law. We need to get all the various medical institutions to show how complaints can be filed and to what extent. Thank you so much.
Thank you very much, Ms. Espinosa. Appreciate your testimony. Very difficult, but thank you. Mr. Robin Marquardt.
Good afternoon. I'm in favor of your bill. Perhaps with some caveat, because it's correct. Innocent until proven guilty. But accountability is what we want. This is what I have left of my mom. She died at age 75. She would say about herself, I'm going to live to 88, so that would have been 13 more years. She died on August 2nd, 2018, the 5th anniversary of my real estate brokerage. I took care of my mom for 5 years. I'm not currently licensed. I did not have time to relicense. At the time before she passed away, we were going to build a house. And some of you may recall that the last hearing on June 22nd, I brought up a word, makmamao. I got that word from a calendar from Bank Pacific. And that calendar has all the months and lots of Chamorro stuff in there, Chamorro words in there, which I love. I have that calendar. It's probably 8 years old. My mom and I, we were going to build a brand new house. I'm also a general contractor since 2000. Those things we were going to do together died with her, including me hearing her speak Chamorro. So accountability is what we want. The caveats could be court pending versus judge court decision made, something like that, in this website you're proposing to develop. Going back, and this is an impact statement, going back to the day my mom died, could an aspirin have could an aspirin have saved my mom? Because I don't know what the doctor gave my mom, but he gave her a shot in the arm. So she's already passed out, and she grunts. That was the last verbalization I got to hear from her. I asked the doctor, how long have you been a doctor? Because he looked young. I'm going to guess he was 33. I think he was about 33, if not 27. I forget the age. Young doctor in the ER. As I've mentioned to others before, when they let my mom out of the hospital, and this is at GRMC, my sister was there pleading with the nurse to call the doctor. The doctor never came. Right now, I don't remember the doctor's name. I don't remember the attending doctor who never came. I don't remember his or her name. I don't remember and then thereafter, I don't remember the emergency room, the younger doctor's name. But I did finally, on June 22nd, filed a complaint with the medical board. I have the names written down. I'm a bit flustered to remember names sometimes, but I try. We certainly can have something out there that protects, at least, I like learning. I love learning. I have a bachelor's in business administration. I have aspirations to get a law degree. So what's the harm in the public being able to go to a website and seeing every doctor and their standing, an ongoing case or a judged case? That would be that would be a warning label, like there should be warning labels on sodas. The amount of sugar in sodas is deadly. I mentioned teacher. The word doctor means teacher. In Hawaii, it's kumu. And I do appreciate that calendar. I have it at home from Bank Pacific. I refer to it. I've written down all the months, trying to memorize them. But the one that I memorize is makmamao. Make me moke. I mentioned that the last time I was here. Why? Because I'm in favor of decriminalizing all drugs across the board, to be distributed at university supervision and study by manufacturers, dealers, and users. Again, I've been sober for almost 16 years, August 31st. And those same people I just mentioned would have immunity 2 years after the program if the program ever ended. My mom lived to 75 with hopes of us getting her legs. She was a double amputee. So that's what we were going to do after we built the house. And I feel for, why am I here today? Especially because I'm here for my fellow citizens that have lost their loved ones. Mr. Lebowski here and his 5-year-old son. I see me in his son. The impact is there. So trying to do something to protect people, not trying to make villains out of doctors. Just like I want to decriminalize drugs. But it's a good idea. Something to keep them from taking life for granted. That's probably what they're able to do because they deal with death as part of their job. So it's not as impactful for them individually as a doctor, as a stranger to the patient. But our loved ones die. I mentioned the last time I was here how I thought my mom was going to get fixed. So instead of taking her to bingo, I took her to the hospital on Sunday, and she died Thursday. On the 5th anniversary of my real estate company. That's a coincidence. Just like my dad, who I'm not complaining about, he died on Easter Sunday the year before. I'm not complaining about that because we knew we were already advised that he would probably die, and he lasted 3 weeks. 3 weeks. So the 4 days, 3 or 4 days in the hospital, this time with my mom, was a shock. And perhaps having a website might help save some lives. If it saves one life, it worked. Again, I did this for my mom, Blandina. I did this for Asher. And I hope we can help some people. In Jesus Christ's name, I pray, amen.
Thank you, Mr. Marquardt.
Thank you, too.
All right. We're going to open it up to questions. I was hoping the HPLO would be here because I wanted to ask them to update us on the status of compliance with this law, the existing law, and the inputting of the data. Because of course this would ask them to input additional data, which is the current accusations pending. And so I of course want to see how they are, because they had assured us the last time that they were working on it. They had a methodology to it, and how much that they expected to accomplish in updating that data. And I was satisfied that they were making their best efforts to update the information on this physician profile for patient access. And I, for one, I also want to ask HPLO a little bit about the budget, because there's been some, well, there's always a response about resources and budgeting. And I brought this up at the budget hearing that we had for the Department of Public Health and Social Services, where HPLO had received $286,000 last year, was only requesting $125,000 this year. They wanted additional personnel, less, $30,000 less for contractual, $22,000 less for office space, $3,000 less for supplies and materials, $1,900 more for miscellaneous, 1 additional FTE. That was their request. And again, we went through various hearings after hearings and meetings with board members, with HPLO, to make sure that they all understand the money that they bring in, and that is absolutely their right to spend that money and to dictate where that money will be spent. The Guam Board of Medical Examiners, I had a larger printout, which I'm looking for, I can't find right now, but for FY21, brought in 68,000, spent 51,000, had a balance of 17,000 at the end. FY22, as of March, so this needs to be updated, but at that time, they had brought in already 94,000, spent 22,000, and had a balance of 71,000. So I agree, if it's a resource issue, then we need to take care of the resources. But I've also tried to really impress upon the boards that they control these resources, that they need to control these resources, and they've done so. So they've pushed the hiring of the hearings officer and the hiring of a prosecutor, for example. And there's discussion of hiring investigators. It's been going on for years, and this is really the issue. I, too, Mr. Marquardt, am not after any physician, not one in particular, not them in general, despite what the public might, some physicians say. That's not my point. My point is this: when we review the data, the complaints have been sitting for many years, and I just don't find that to be acceptable. So we've tried to find ways to help them. Not a single hearing on a complaint has occurred. I think ever, but I know for sure since 2018, since I've been keeping track. Not a single hearing. That means there's been no no prosecution, or it's not even a prosecution. What it is these physicians, if there is no adverse finding against them, continue to be licensed, and that is the issue. They continue to have full licensure privileges on Guam unless the board has a hearing. You cannot take away their license, so you need a hearing to do that. In the interim, if it takes years, patients are going to these doctors, and that's really my issue. So I'm trying to find a compromise between waiting years for a final determination that that doctor was doing something that should not be done to one patient, let alone all the others since that one patient complained. And the balance between, as Dr. David said, of course, innocent until proven guilty. And I was trying to do that, and I looked very carefully at the statute. Complaints filed by the Attorney General's office, those are public according to this law. Those are the complaints, not the convictions, the complaints. And so no one, I went back through the hearing on the original law. No one objected to that. And then I tried to still accommodate innocent until proven guilty and give some reasonable time for the board to act, especially to clear. If they're frivolous complaints, if they are something you can see right away, this is nothing, then clear it, do something, and at least there's a final determination, and then those doctors will be cleared. And so I thought it would be reasonable 6 months. And so if there's another time period that you feel might be more reasonable, I might consider that, right? But I'm trying, there's a balance here. We cannot wait years and years while we continue to license. And I want to commend the board on its recent efforts. They have, since our oversight hearings, we've noticed that they have actually put some restrictions on licensing physicians pending the adjudication of those complaints, the full adjudication with a hearings officer. And so those are moving, and that's progress. And I feel that's huge progress. That's huge progress that we have not seen. And so I'm very grateful to the current board members for doing that. I say we need to just do a lot more of it. We need to do it in all of the pending cases. At the last oversight hearing, we went through the list of pending cases. And it's not very satisfying to see the numerous cases unresolved for so many years. And I am not trying to put additional burden on anyone. I am not trying to take away anyone's practice unnecessarily, and that's the balance. If we can't take away a person's license right away, we have to give them due process. Well, what about the patients, right? And what about, and we have, unfortunately, the accusations are same physician, we've seen this, same physician, repeated accusations. And what are we as a community going to do in response to that? And that's what we're trying to find here is a balance to that. And that's pretty much my intention. So I don't know, I guess in response to that, I'm gonna ask any one of you if you've got any other suggestions to make, and if not, I'm gonna ask my colleagues, of course, to ask any question. I'd like to ask the board member, yes, Ms. Espinosa.
Just, no, am I turning it the wrong way?
That's good.
Okay. I was doing a lot of research with the Medicare program, and do you know that actually it was the Part D, you know, where they pay for your medicine, and they have a paid positions for patient advocates. And I feel that it's very important, especially in the medical field. You need to have somebody that can get on top of these things and to help the patients pursue what they feel they deserve. And that would be a worthwhile investment to have a paid position or two for patient advocate. Because you do have it at GMH, they are paid and they do it, but I think it's, you know, maybe their rules and regs are bound and I don't know, I never had anybody tell me I could go beyond the hospital. I didn't know that you could go to a board. So either they have an additional page with a chart. I like charts, maybe other people don't like charts, but it shows you complain to the patient affairs office, you're not satisfied, you go write a letter to the director, you go, just like that.
Absolutely, I take that recommendation very seriously, and it is a great point that the board does good work. If they're going to adjudicate cases, then the complaints need to get to them, and we need to, again, reach out and make sure everyone knows that this is available to them. Dr. David, can you confirm, or Mr. Flores, can you confirm, when you are licensing a physician, are you privy to complaints in other jurisdictions that have not been finally resolved?
So when we review applications, Madam Speaker, we go through all the reports that are given to us, including any reports from the National Practitioner Data Bank and from the FSMB, the Federation for Credentialing Verification Services. So I think that those reports would then flag any violations, any sentencing, any licensure irregularities from other states, and that is a very important step. I also wanted to let you know I'm looking at the agenda for this week's GBME, where we look at existing complaints from the long list that you had during the initial hearings. It's now down to 6 complaints. The oldest is one from 2020, and then one from 2021, which is ongoing, and then the rest are from 2022. So there has been some movement.
Oh, I want to thank you, Dr. David. Maybe it's your presence on the board that has really contributed to this, because
it's the whole group, including the HPLO.
We couldn't do it without her.
It's teamwork.
I'm just joking. I agree. And I have noticed that the HPL office has really kicked it up. So I wanted to commend them when they came here, because I know that they've worked very hard and they were very responsive to all of our questions, and that they I was convinced that they really have good intentions to not only keep the patients informed or the complainants informed as to the progress of the case. They committed to do that at the hearing. It's actually required by the statute already, and that they were doing that, and that, so we had seen that. And so I wanted to thank them for that. So thank you for clearing some of those cases.
Madam
Do you get
Speaker.
access, Dr. David, do you get access to complaints made in other jurisdictions that are not resolved?
That can be difficult. I know from the cases that I have had to handle, in some cases we have written to boards in other states asking for details, and we have been turned down.
Okay,
And I think part of that has to do with confidentiality agreements.
okay, thank you. Mr. Flores?
And Madam Speaker, do you say that the HPLO is asking for less money in this upcoming budget than we have now?
I think so.
Oh, well, that'll be on the agenda on Wednesday, and I'd like to discuss it. But the numbers you were reading about collecting funds and some left over, I think those were year-to-date comparisons. So neither of them was a complete year. It was a year-to-date comparison on how much money we have left.
Well, 2022 wasn't complete, that's correct. But on almost every year that we reviewed GBME, they had a balance left.
But the fees that we collect, they ebb and flow, because during
Yes. 2 years, right?
the odd years, everybody files. During the even years, only new applicants file. So that really does a lot to the cash flow. But that'll be my first phone call when I get back to the office, is to talk about budget, because we do need money to hire a professional prosecutor, and more so investigators, because you can't ask Dr. David, you can't ask me to go figure. First, I can't figure out anything with medicine. I'll always be asking the other board members, but they have full-time jobs, and an investigator it's not so much a talent, but it's certainly something that somebody has to have experience in, and I don't see the physicians on our board having the time to do what they do and then go delve in deeply into investigating. Now, with respect to the office itself, how it's turned around a bit, Xenia is, I don't want to get the last administration mad at me, but Xenia is 1,000 times better than our previous administrator at that office, and she's very conscientious. We used to always meet at the GMH, and we bring all the files that we're working on to GMH. We'd meet in the boardroom. Xenia came in and says, you can't do that. You can't keep bringing files out of the office and transporting them. And so that's why we now meet at the Terlaje building, where everybody else is. And I think she's done a really good job. Can we do better? Do we always have to have a light lit under us? Absolutely, both. But we'll address budget this Wednesday.
Thank you. And so Xenia during COVID had been detailed to various locations in public health and throughout the island. And but the staff that was assigned there are
Excellent
new staff.
people.
They're excellent. They are
Brianna
very
and
good,
Jay,
and I would
yes.
urge you to work with them. They're Brianna in particular. We worked with her, and we felt no inhibition of just cooperation and providing information that we needed, our committee. So I want to commend them. And and the status of the cases now. Thank you, Dr. David. I'm very happy to hear that. One more thing I wanted to ask was, well, nothing. But did you have something to say, Mr. Levosky, to add to?
I'm sorry. I just wanted to make two comments. The idea of innocent to proven guilty is really relevant, and I agree with Dr. David, except there's this other side to this. Consumers don't have that process. We can't go through a legal process. We have no alternatives. So for us, doctors will always be innocent because we can't go to court. We have the MMAA, as you know, that blocks us. So accusations are important to protect other people. And yes, innocent to proven guilty, if it applies on both sides. But there's no process for us to be able to move forward. That's the first thing. And I think, Speaker, I heard you say that the boards are informing consumers more now than before. I have never heard from, and I have several cases, I have never heard from any board member or any board or the HPLO office on anything regarding my cases at the medical board or at the nursing board or at the allied board. I've never heard anything from anyone.
Okay,
So
then,
if people are saying that, and I've got the most
Yes.
active cases, not a word. And I asked my attorney that too, and she told me, never heard anything. So
okay.
I don't know who's saying that, but
All right, well, I'll double check on that then, and my apologies if that's inaccurate. Thank you, Mr. DeVos.
thank you, Speaker.
All right, colleagues, Senator Perez?
Thank you, Madam Speaker. Thank you to everyone who came here today to testify. Yeah, I do agree that timelines are important. Education about grievance procedures is very important too, and I think I'm really thankful that the speaker has actually pursued this. From the very beginning, there was issues about complaints languishing for years, and I'm glad to see that those cases are being addressed expeditiously as much as possible. So I guess as far as timelines, 6 months, is that a good timeline to I guess, for anyone here who can address that, 6 months?
The answer to that, Senator, would be it depends. So it depends on the nature of the complaint. This is in my experience. It depends on how cooperative the complainant is. Sometimes, in my experience, it's difficult to get them to respond. I, for instance, try to make it a point to have conferences with the complainants, to speak to them, whether it's through Zoom or through face-to-face. And some are much more forthcoming and others are more reluctant. And because, some of them have to deal with the trauma also, and it's not easy for them. It also depends on whether we have the access to the experts that we sometimes need to bring on the case and on the investigator. I can tell you that for the current investigator that we have, the process took nearly 2 years to bring them on board because of the procurement process. And Senator Therese knows that because we've been dialoguing with her to ask for help to facilitate that, to get the experts, for instance, there are specialties that we don't have on island. And so when there are cases that involve those areas of medicine, we sometimes have to refer to outside experts, and bringing them on board, again, is a procurement issue and can be very much delayed. And the process is outside of our hands. It is in the hands of GSA and DOA. So the answer to that is it depends. Can we get the support, the technical support and expertise that we need expeditiously? And can we have an investigator who is on the case immediately? And those processes are outside of the control of the board.
Would anyone else like to respond on the panel?
With the Government Claims Act, if you file a case against GMH, they have 6 months to respond before it goes to a different level. So I would think, and personally, I'd like to see it less time, but we have to be realistic and practical. Since the government claims does 6 months, I would think that 6 months would be, as a consumer, would be fine. I know people are also busy. And it follows law with the Government Claims Act. Thank you.
Idea, 4 months, 3 months a quarter, plus one extra month is 4 months, plus 2 extra months as a kind of a buffer or extra time, because again, 6 months seems like a long time. So it should be like 3 months with the extra month and then extra 2 months to like, come on, hurry up, what's taking so long? In addition to the adding a separate entity to investigate.
Thank you. Mrs. Espinosa?
I'd like to share, because of a doctor's reference to the funding and that probably a line item on their budget requests would be to have contractual flexibility so that they're able to have funds specific to authorizing an investigator or a specialist in the field. They shouldn't have to be constantly, for every case, have to go back to request money for this and for that. They should have a budget specifically for that so that they have the flexibility to call on people.
Thank you, everybody. Also, in regards to settlements, I know, David Lebowski, you mentioned that settlements are not public, is not published.
The way the law is, I'm not sure if it's the law, but the way they do it now at the board, and I've read up on this as much as I can, they found a way to, the legal counsel for the board has found a way not to include settlements. So in other words, even if a doctor makes a legal settlement, wrongful death, or whatever the term is that they use, that settlement will not show up underneath their name unless I think they have 3 settlements or something ridiculous like that. So in other words, if a doctor has a settlement for wrongful death and he was brought to court or whatever the process may have entailed and that came to the settlement, that is not on the web page. They found a way to make it so that people with accusations one step further with settlements, which is not an accusation, it's an actual legal settlement, they don't include it on their web page. And for sure, settlement for wrongful death or for anything else should be on a doctor's profile. Not wait until 3 settlements, because most people can't afford to get past 1 with the current system. That's a fact. You can ask legal counsel. Maybe these folks know it. Thank you.
Thank you. Dr. David, have you been able to access any settlements in regards to potential licensees?
So,
Yes. Yeah.
I know in at least one case that I handled, we've written to 2 separate. So at least in one of the cases that I'm handling, we have written to 2 separate states, medical boards, and they have not provided us information on settlements. So what we are able to access are whatever is publicly available. Phil, I'm not sure. I haven't handled any other. I don't know if you have.
Do you think we can require that of people who want to get licensed here, to require that information, they can provide that information voluntarily or require it? I mean,
It's in, I believe, if I'm not mistaken, it's already in the law that they must disclose any history. Am I right, Phil? I'm just trying to recall. I don't have the medical practice.
I'm not
Act in
sure.
front of
I'm
me.
not sure. I'm not sure either. But the information in the national database that we get for every applicant, is that confidential? In the sense that, can we put that on our website?
I think there were issues of confidentiality that were raised by the legal
because
counsel.
almost everybody who applies for a license, I'm not going to say almost, maybe a third of them have some type of settlement. And if you've been in, I found this out when I first joined the board, and all the physicians said, if you've been a physician for long enough, especially a surgeon, odds are you have some type of settlement in your history. But some of them will be serious, and then we're going to take a real serious look at it. I mean, they're all get serious, but some of them, you can tell by the size of the settlement how serious it is. But I don't know if we're able to put that on.
I do know for the application form for people who are applying for the first time that there is an item that asks them, have you ever had any convictions, settlements, or anything like that? And it's supposed to be self-reported. So that is on the form, but it relies on the honesty of the applicant. Yeah.
I know when I'm looking at applications, I'm looking where else they're allowed to work, where they have a license, because most of our applicants coming in are licensed elsewhere. So I'd look to see whether they're licensed elsewhere. We all look to see if the license has ever been suspended or revoked, because that's the huge of all the red flags. And I don't know if we've even approved anybody who's had their license revoked. Or,
No, we have turned down.
Yeah.
We've turned down a number.
I guess another question I might have too is, you'd mentioned, Dr. David, you mentioned that sometimes it takes longer to obtain the public hearing officer or the expertise to handle the case, adjudicate the case. I guess in your experience, what are some of the procedures that the board is doing to kind of alleviate that?
Well, like I said, it had to take 2 years to be able to complete the process to bring an investigator and a hearing officer on board, but they are not on long. These are short-term, time-limited contracts. And one of the things I was going to suggest for the next bill, in fact, was to find a way to ensure sustainability in having investigators and hearing officers for the board.
Senator Vick, so from the current information that's required, is also historical information to be published, includes all settlements within the last 5 years and the possession, custody, or control of the board shall be disclosed if there are 4 or more settlements for that licensee within the last 5 years. That's board settlements. Sorry, there was another one. Here, civil judgments issued in any amount that were not reversed on appeal, and arbitration awards issued in any amount for a claim or action for damages for death or personal injury caused by the physician and surgeons. Yeah, so I don't see any, no, sorry, here 10. All settlements, no, that's the same. So it's only board settlements, and then in the civil judgments, it's only the judgment's not a settlement. So I think Mr. Bossi is correct.
Okay, thank you for that. Maybe one more question. So do you think, this question I guess is for Phil Flores or Dr. David. So in regards to pending adjudications, would you recommend that maybe there are restrictions on licensure?
I don't understand that.
So I guess while a case is being adjudicated, would you recommend licensure restrictions?
I'm having a hard time understanding anybody who has a mask on. But, okay, thank you.
Sorry. So in the case where cases are pending adjudication, would you recommend licensure restrictions?
And we have.
Okay.
I think
We have one right now.
It depends also on the nature of the case, Senator. I think that's a judgment that needs to be taken on a case-to-case basis. It depends on the nature of the complaint.
Does that include suspension?
Yes, but the law does state that if we do that, we must be able to provide a hearing within 30 days of that order. And if we don't have an investigator and hearing officer on hand, that might impact the complaint itself. Okay. Which all goes back to ensuring that there is someone on staff for the board as investigator and hearing officer. And I was going to say that in CNMI, for example, they're much smaller than us, but their board includes a line item for an investigator separate from their legal counsel. And perhaps that's the model that we need here in Guam if we want to see true action and true change.
Okay, appreciate it. Thank you so much. Thank you.
I'm sorry, Senator. So it does require the board to publish settlements, but only, again, if the settlement by the physician, if that settlement is in the possession, custody, or control of the board, and there are 4 or more settlements for that licensee within the last 5 years, then the board must publish, and then there's all kinds of criteria here, settlements in an amount of $30,000 or more for damages for death, personal injury, caused by negligence, error, or omission, or is rendering of unauthorized professional services. And so I think Dr. DeWitt's point is good. If it's not in your possession today, it could be in your possession if you require it to be by the application forms, right? There is also another provision of the statute that we've been trying to follow up with the boards to where the malpractice insurance companies are supposed to report to the boards all of their information, and they have not. We followed up with the Department of Revenue and Taxation for the insurance licensing board, and still no response from them. Maybe you can help me with that, Senator. Senator Duenas? Oh, sorry, Mr. Lebowski.
As it stands now, from my experience and from attending the board meetings, or watching them anyways, is that if a doctor has a settlement against them for wrongful death, medical negligence, it will not be reported online. Part of the problem with that is 4 settlements in 5 years, it's like it's impossible. Those are not accusations. Those are real settlements. They should be listed on the board's profile. They're not listed. And also, one step further, based on what you said, Speaker, about insurance companies. GMH is considered an entity that's also supposed to report. The AG gave an opinion about this a few years back. GMH is supposed to report all medical negligence cases to the board, and the board's supposed to do whatever they do with the information, and it's supposedly to the feds also. That has been a big problem. GMH has not been doing that. But these cases should be reported to the board as well, not just insurance companies. I just want to add that. Thank you.
Thank you so much, and you're correct. There's a whole list of mandatory reporting. All physicians, licensed healthcare providers, state medical associations, the medical associations, all hospitals and other healthcare institutions, clinics, managed care organizations, all government with services involving healthcare activities, all law enforcement agencies, all courts in Guam, all peer review bodies in Guam, and that they're also supposed to report voluntary resignation from the staff of a healthcare organization to the board. And then the malpractice insurance carriers are supposed to report. So there's a whole long list also in 12212, which is not being amended by this bill. Yes. Senator Duenas.
Cesar Masi, Madam Chair, and I want to thank everyone for being here today. Certainly understand the sensitivities of this issue going forward. Madam Speaker, after the line of questioning from my colleague, Senator Perez, I think there may be something to work with here, listening to Dr. David. And of course, I would like the board to take this up, and I think we have the commitment from Phil Flores to ensure that this gets discussed in the next regularly held meeting so that they can officially formulate a position. But I think that, Dr. David, I might want to kind of work off of my colleagues' discussion on the reasonable time frame. Maybe there's a trigger to, a reasonable trigger to the 6 months in terms of notification and all involved having the opportunity to respond. Any thoughts on that?
So again, Senator Dueñas, a lot of it depends on the nature of the complaint also and what needs to be done to act on the complaint. Some of the complaints are relatively straightforward and have been able to been worked on and a decision reached with the current board, but some of them are more complex. And like I said, the members of the board, there are certain specialties where we do not have the expertise within the board, and so we have to look to external experts for that. So in the end, the time frame really depends on how soon we can access the external support that we would need. So it's hard to give a formula for all the cases, I guess is what I'm trying to say.
Yeah, I mean, I can really see the difficulty. I mean, I can really see the need to have, to have that ability, and I think that's why the 6 months was put in here, to have that ability to try to, vet what's going to go up and be posted, but then the other side of it is to have a prolonged situation also where, you have individuals that are seeking resolution and those that are going on the site to, kind of ascertain and make a judgment if that's something that, a family or potential patients would do to try to figure out, the current picture of Guam's health system and complaints. It just seems like it's something we should work on. And like I said, I mean, while yes, it could be determined by the complexity of the case, if there was a trigger to where all parties are notified, all parties are currently, it's active, investigation is active and everything else, if you had like a 3-month trigger on that, it said everybody should have been fairly noticed, it should be underway. And then from that point on, you got the time frame of the 6 months, and then no resolution, something has to give. So I look forward to the committee work going forward. I look forward to, I'm sure that this will be active and lively discussion in the next board meeting, and I'm sure that once physicians become aware of the potentiality of this bill, we'll get more feedback. I concur with the speaker. I'm a little disappointed with the HPLO not being here today and kind of understanding how there might be a middle ground here, but I look forward to the committee work going forward on this and getting additional information, Madam Chair. I certainly understand the intent and want to follow it to the process. Just Masi.
Thank you, Senator Dueñas. Senator Brown.
Thank you very much, Madam Speaker, and certainly thank you to all of you that have come to provide your testimony on this bill. I think the challenge that needs to be addressed, and the real issue, obviously, which I think that this bill is intended to try to address, is the lack of responsiveness that's needed by the community, have some sense of confidence that the medical board is properly addressing these issues that are brought forth. I think we can all appreciate all the time, effort, and work and dedication that any medical professional puts into what they do, even just going through your educational process. All the years it's invested to become a professional doctor, whatever the case may be. But in reality, there are times when bad decisions get made. There are times when you have an individual who is in this profession who does not act ethically or properly. And in those cases, there has to be a recourse to where these issues can be addressed. Probably for most of us, you are the most vulnerable when you're going to see your doctor. I feel like a 5-year-old sometimes because my doctor will tell Joanne, you're a little high on this, you need to work on that. It's like, oh, okay. Because you're the most vulnerable. You're there because it's something that affects your physical being or a physical being of a loved one that you might be there for supporting. And this is the engine that we operate with, our physical body. And we always hope that the doctor that we're seeing is there to take care and advise us on the best procedure or process that we need to go through to maintain our health and well-being. What I've observed in the last year and a half being here in this current legislature is that's really an outstanding issue, because the board will come back and say, you know, we only meet twice a month or once a month. We don't have, you know, adequate staff because the staff has to spread themselves over other boards. We're not able to, you know, do all the things that we need to do because we're volunteering. And nevertheless, these issues get left on the table, and then you have individuals in the community that, because they believe that something has gone wrong, and granted, life is not forever. I think I recognize that. We're not here forever, and we are going to suffer ailments, and probably as time goes on, as we all get older, we're all going to have physical issues to deal with. And, you know, when our time's up, you know, God decides our time is up, but when we feel something may have happened improperly, what is the recourse? And I very much feel, and certainly myself even as a resident, that our people don't feel there is a recourse to properly address that the current system is not adequately in place to do so. And until we address that core issue that is before us, these type of pieces of legislation are going to continue to come up to bring to light that this inadequacy continues to exist. Because God forbid, if it was a loved one or myself and I felt, you know, a doctor was not being very professional in my care, and it's something that I was injured by, worse off if it's a loved one of mine, to what extent would I go? And some people have more resources than others. Some people have more stature in this community than others. But that should never be a determination to the fairness of how our medical practice is you know, executed on Guam. So I can only recommend, and I think we just want to see, is what corrective action needs to take place. Is it, and I know it was discussed with the whole medical malpractice issue last year and all the attention that was placed on that, and everyone was up in arms about it. But some solutions were put on the table, but it's kind of been left aside. I mean, you know, getting through COVID and everything. But I think we need to come back to the table to look at what kind of agreements can we come to put in place so that the inadequacies that continue to exist can be addressed. Getting the staffing capacity and the support that's needed to properly address and review these cases as they come forth. Granted, if I was a medical professional and someone's just disgruntled with me and they make a frivolous complaint that can be obviously very harmful to me, my career, I'd be very concerned, because they could take everything that I have worked for so many years. If I believe I'm a good doctor administering care to my patients, my credibility in 2 seconds could just totally disappear. And yet, what recourse do I have to show or prove that maybe I didn't do anything wrong? Where do I go as a physician? Any more than where does any resident go when they feel they or a loved one of theirs you know, was not properly addressed by a physician? They felt some wrong or some harm had come. Where do they go now? If the cases are going to continue to stack up and there's no resolution one way or the other, these issues continue to sit in limbo, and the continued distrust that is here in our community will continue to grow. And every time we raise these issues, you know, we're being accused by doctors in our community that we're not educated, we're not smart, we don't know what we're doing, and we don't care, and we're trying to destroy the medical community. I mean, these extremes are not going to get us anywhere, and it's not going to have us come to some solution to how do we address, what recourse do the people of Guam have, and also what recourse do doctors have and other medical, you know, care people have if they have no means of getting these issues resolved either, if those accusations are made against them. And it can happen to anybody at any time. Where do we go? Where do we go if we file a complaint and we have to keep coming and knocking on the door a year, 2 years later and go, what happened to my complaint? What happens if that medical physician does harm to someone else? Legitimately does. I'm not saying, I don't think anyone would spend all these years in this profession to do what they do to bring harm, but what if they do? What if there's just a wire somewhere that's just off? So I think until we address that core issue, which to me is not insurmountable, we're going to continue to see pieces of legislation like this that come up. And people are going to say, well, why are you going to put this just based on an accusation that has never been determined to be truthful? Because I would think if I was accused, I mean, we know what it's like. We get accused every day of all kinds of things. Go to social media. That's why I don't spend a lot of time reading garbage on social media, because heck, every one of us here at some point or the other, if we're at the disagreement or it's election time, you know, they don't like you, they don't like your party, whatever. We know what it's like to be dragged to the coals publicly, our name, our credibility, everything we've worked for, you know, thrown in the trash can. If you survive it, then you're still standing, you know. Comes with the territory. But if I was a medical doctor being accused, and like I said, if I have no recourse to have this issue resolved, I mean, that's just like being a politician that people don't believe in. Yeah, you could lose your career or lose your patients, use your credibility. And our concern is we certainly don't want someone else who doesn't have that in another jurisdiction come here because, oh, let's go to far end territory in Guam and then harm people there. I mean, none of us want to see that. So I just think for those and those of you that sit on the board, I think that we need to come back to the table and look at addressing, because these issues are not insurmountable. I mean, some of our colleagues think money's falling from the sky to spend on everything else. Why aren't we putting a little more money to this, or how do we generate additional funds so that you can get adequate staff to assist so that proper decisions can be reviewed and made and determinations can be, you know, come into place so there is response to these complaints. That's really where I see this going, because otherwise we will see more and more pieces of legislation as more people knock on our door and continue to relay their dissatisfaction with the medical board not properly reviewing these cases and coming to a determination.
Can I ask a question?
Sure.
She was referring to the agenda, and I was wondering, do they list the case, like the patient versus the doctor?
They
No
list the
names?
cases by case number,
Oh, case
and so
number.
each patient should
Okay.
know their own case number.
Well, maybe I didn't get to look at all of the in their website, but there should be a listing on the website of the case numbers in order of filing, so that way we know that it's still there, that nobody just deleted it, and if it is
I see.
missing and we know
Yeah.
that it was never resolved, that we'll be able to call and demand an explanation of why it's not there in the.
They are required now, pursuant to Senator Brown's law, to publish their agendas as well. So that's how we are able to find that information.
Yeah.
Yeah, Madam Speaker, I have no argument against the need for transparency, but I understand where some of the concerns can be raised that's simply based on an accusation. It's something that's going to be published. I mean, but again, I don't think if we don't address the core issue, this
No,
type of legislation is going to continue to come before
But
us.
listing the case numbers is not listing anybody's names on either side, but it keeps the public aware that it's there, and it gets into the agenda. We'll know when it shows up in the agenda by case number. So there's that element of privacy there.
Yeah, no argument, but I think the problem is these cases don't go anywhere. That's the problem. I mean, the complaints get made, but they're not properly addressed in what most reasonable people would consider a timely manner. That's really the issue. But thank you, Mrs. Penosa. Thank you very much, Madam Speaker, for the opportunity to
Thank you
comment on
very
this.
much, Senator Brown. I guess I just want to make a suggestion to the board then, because we've been told today at the hearing that not all complainants are being contacted, contrary to what I said or what I believe based on what I was told. And so if you maybe request for an update from the HPLO office, a report or something during each of your meetings where they can just tell you, you know, a checklist of things that you want to know. One is, are these complainants contacted regarding their status of their cases? Have all of them, or are there some that are still pending? So that you are aware, and they can tell you if there's any impediment. What's the impediment to that? Because I was assured that that was going to happen. And then, yes, Senator Brown brought up the medical malpractice bill. It was at that hearing, in fact, or the many hearings that we had on that, where so many of the doctors said, leave it to the licensing board. Let them deal with the complaints that are made there. Let this board handle it. They're doctors. They know better than all of us. Let them handle it. And the issue was that when we looked at the board, they were not handling it at that time. I didn't think. The claims languished. The laws are not being followed necessarily, and we all need to work together to get that done. Reports are not being made, and that's where the mistrust happens, I think. And so I'm trying to help. We're going to build the trust of the community in the board in doing its licensing role, and in every other sector if possible. So I hope you will see and help me in this regard, and that all the physicians can see it that way, that it's in all of our interests. And I know all of these physicians claim we do not want bad physicians here. We want to take care of that, right? And they all want that. So this is just one way. And we're trying to not get into a situation that we have actually had. And this is not a myth. It's reality that the cases languished. And so now that we're able to see them more and discuss them more, I see much more progress, and I'm so very grateful. So again, please discuss with your board the 6 months, if that is not possible, maybe to describe some caveats, right? Like why would it take longer than 6 months, and just put those down in writing and for some reason, you know, or assurances that are made, like it's a very complex case. How many of those cases are there? We don't know because we are not privy to the cases at all. All right, so I'm going to end there. This is, I want to thank everyone for providing feedback on Bill number 317. And those that submitted written testimony as well. All of the senators were given copies of the testimony, and they will also be included in the committee report. So the second item on our agenda, and if you're not going to stay for the next items, you are excused and free to leave. The next item on our agenda is Bill number 318. I'm going to introduce this bill quickly. It's a bill that was introduced to address another one of the prevailing issues. There was a dissatisfaction with the current level of general public representation on the Guam Board of Medical Examiners. The concern is a result of their sometimes patients dealing with the board relative to the status and results of complaints, requests for information, and communications that take place amongst the board members and with complainants at board meetings. Some of these patients have advocated that the legislature assist with increasing the level of representation and input from the general public in the decisions made by the board to help ensure that patient health and safety is first and foremost. During the February 16, 2022 oversight hearing, this call for our action was again made by some of those present at that hearing. So the intent of Bill number 318 is to amend the current law to allow that in addition to a nomination and appointment of a board member made by the governor with the consent of the legislature, that at least 2 of the 7 members shall be appointed from the public at large. Currently, it's only 1 of the 7 members appointed by the public at large. That is Mr. Phil Flores here, who is currently serving as the public member. All other members are physicians. 1 member is the medical advisor of the Guam Memorial Hospital, and all others are appointed with advice and consent by the appointed by the governor, advice and consent by the legislature. So I added to the bill that medical societies and associations may conduct elections periodically, but no less than every 2 years, to determine nominees for the board to be submitted. In making appointments, Imagalahan Guahan may consider recommendations submitted by the medical societies and the public at large, but I did not restrict her to that pool. This is just to give other physicians also some kind of input as to who they think should serve on the board and make that public and for our consideration. So again, all the bill does is it changes 1 physician member to a public at large member, so that would be 2 out of 7. It also changes the term so that all newly appointed members after October 1, 2022 shall serve for 3 years. And this will not affect anyone in their current terms. It will allow them to continue in their current terms. I had asked, again, the Attorney General's office to clarify for me the current language of the statute and whether, how long the terms actually were, because it's kind of confusing. And so I did get a response at 1:22 p.m. today that says, in working on our response, we began to identify some issues regarding clarity of board members' terms under 10 GCA 12203A4. However, we are aware you've since introduced Bill 318 addressing the issue of board members' terms. We believe Bill 318 sufficiently addresses and provides helpful clarification on this issue. It would also appear to render your initial request to our office as moot, so we will not be proceeding with a further response. However, please let us know of any further questions. That's from Stephanie Mendiola, Deputy Attorney General. Okay, on this one, we've got BBMR with the same no fiscal impact upon funds of the government of Guam. All right. Is there anyone who'd like to provide testimony on Bill 318? Okay, so we'll proceed again. Mr. Lebowski.
Thank you again, Senators and Speaker, for allowing me to give testimony. The Guam Board of Medical Examiners is supposed to play a crucial role in protecting the people of Guam, which is in fact their mission. It's important to spell out precisely how much time each board member can serve on the board, especially since, as an example, the Allied Board with the same legal counsel has board members sitting for 20 years. As I recall, the Assistant AG, Rob Weinberg, at one time said a past AG opinion was that if you were already sitting on the board when that law that the Speaker referred to was enacted, you can continue sitting unless the governor reappointed you. So there are members who have been on boards 20 years. With all the reported problems of the Guam Medical Board and the complaints, consumers will at least know that conflicts of interest and other issues that exist will be at least mitigated by changing board members. The law will be more clear of how long someone can serve. For me, the most exciting aspect about Bill 318 is adding another member from the public. Public board members help to restore public trust and helps to underscore the medical board's independence from special interest groups. On Guam, as we've heard over and over, there's a growing perception that the medical board is beholden to physicians rather than the public it serves to protect. As I said earlier, no case has ever been decided for a complainant under the current board. It's my opinion that currently the member from the public board, Mr. Flores, has downplayed how important his position is. I heard Mr. Flores one time say during a meeting that he was learning so much from doctors. And I wrote to Mr. Flores, and I said to him, I sent him an email, I said to him, I reminded him that doctors should be learning from him as well. They should be learning the patient side of the story. Or they should be learning, the board should be learning how to connect with the community. And by the way, connecting with the community for medical boards is crucial. This is not a Guam thing. This is something that's in the literature. I would expect also the public member to help advocate for patient rights in the community as a whole. Public members on medical boards have growing importance across the country. You can ask Mr. Nathaniel Berg about national conferences that discuss this very thing. Even the Guam Bar Association has consumers or non-lawyers involved with them when they do investigations. And from what I'm told, it seems to work out pretty well. There's also this big misunderstanding, like this mistake from some that those members from the public or consumers or regular hardworking citizens cannot be members of medical boards as they do not understand medicine. This is absolutely not true, and I think that Mr. Flores would agree. Consumers do not need to understand medicine as doctors on the boards, each of them are assigned a medical negligence case, will investigate them, and they clearly, and they present the case along with investigative reports that they have paid for now from off island. Further, that belief that only doctors can do this lends itself to a misconception that all doctors understand all medicine from all fields, which is dangerously false. Members from the public also have separate roles as well. In many states, standards are set up for selection of public members to the board, and almost all states have public members on their boards. The Federation of State Medical Boards Foundation, believes that public members bring unique value to the process of medical regulation, and that we should be doing more in the regulatory community to recruit and retain public members. The Citizens Advocacy Center, they did a study a few years back that addressed public members' perceptions about the appropriate percentage of public member representation on the boards. More than 22% of respondents reported that the ideal board composition, medical board composition, would be 1/3 from the community, making adding another member from the public on Guam to the board justified. Be honest with you, for me, it was very exciting to read about consumers or the public on medical boards, and it reminded me about a lot of things. Currently, we don't have any connection with the community on the board. Literature stated that public members are particularly important as the regulatory community seeks to inform the public more effectively about the role of state medical boards. Think about that, connecting the public to the board. Sadly on Guam, I have never seen this board ever reach out to the public in any way. Public members with diverse backgrounds and broad experience in the community organizing can lead board efforts to inform underserved communities about the resources the boards offer. The current Guam board and public member have not reached out to underserved people on Guam, as far as I know. Micronesians, as an example, on island, for the most part, have no idea that the board even exists. Neither does the community at large, except for the negative press. I have spoken to many who've come to me and asked me about problems that they've had with doctors. And people have no, I think I'm speaking a foreign language when I talk about the board. To be honest, every clinic on island should have board pamphlets with information on how to file complaints, connecting the board to the consumer and to the community. And that, by the way, is not me saying that. That's what's done in a lot of places in the country. The public person or people could and should connect the board to the community. Actually, to be honest with you, this was such a big issue in our opinion, and with all the people that I've spoken to over the last 3 years, that we ourselves produced a video at our expense introducing people to the Guam Board of Medical Examiners process. The video runs on Facebook. It's a very nice video, by the way. Therefore, a second public board member is crucial and will help give the public more access to the board. It will allow for more accountability as to what the board does or does not do as well, with extra eyes on the process. This is an important reason. More accountability overall with the board to the public, and more trust to show the board is not beholden to special interest groups, or is not about just protecting doctors, not consumers. It's my opinion, any resistance to this idea by the board or doctors on Guam is not based on national trends, because you can go research this right now. The national trends are actually exciting. It's not based on experience, and it's not based on recommended board membership nationally. resistance would be based on the same reasons that we are here today. For a lack of transparency by the board and the overall need to protect doctors and not consumers. Please pass Bill 318. Thank you so much.
Thank you very much, Mr. Lubofsky. Did you submit that to us? Okay, do you have copies of that? Okay, sorry, I'm the only one. I misplaced my copy, but thank you. I appreciate that the other jurisdictions that you also discussed. Thank you very much. So Dr. David?
Thank you again, Madam Speaker.
I'm sorry, Dr. David. I failed in introducing the bill to add that other part, that I did also put a cap on the number of terms that a board member could serve. I limited it from the current cap of 3 terms by 4 years, which is 12 years, to a cap of 2 terms with a term of 3 years, that would be 6 years. So it changes it from 3 to 2 terms and from 6 to 12 years. I mean 12 to 6 years cap. Thank you. Dr. David.
I'm one of the newer board members. I was asked to fill in at the end of 2019 when Dr. Joan Gill went off island and then was appointed to I'm serving my first term in 2020. And for whatever reason, most of the cases assigned to me have not been clinical cases, but have been cases of professional behavior and misconduct. But you all know me as a data-driven person who's really promoted the use of data for decision making. And so if I were to look at the cases that I've at least seen for the entire board and the applications that we've had to flag because of issues, I would say about 60% of those are directly related to clinical care issues, the quality of care and medical practice guidelines adherence. About 30% have to do with patient-doctor communication, oftentimes arising from issues of physician impairment, whether it's because of substance abuse or alcohol or mental health issues. And only about 10% really have to do with non-clinical issues that relate to behavior and misconduct. So I think it's important not to underplay the role of having medical professionals who understand what the medical practice guidelines are and who are able to have the ability to discern when clinical care is compromised, because majority of the cases still have that. Having said that, I do agree that it's important to have community representation. I've always been an advocate for community being part of the table for any policy body. And so I think it's a good idea to add on another person to represent the community to the board. But I would strongly urge you, don't do this at the expense of the physicians. Maybe don't remove a physician, but maybe just add on another position who would be filled by somebody representing the community. So if you were to do that, then we would have a total of 8 board members, 2 of which would be community representatives, which would be consistent with the Federation of State Medical Boards policy paper on the elements of a state medical and osteopathic board adopted by the FSMB in April 2015, where they recommend at least 25% of the board should be public members. So that would be a suggestion I would make. I think in terms of having medical societies submit nominations, that's a good idea as well. We always need fresh members, fresh potential people to join the board. That always adds value. Whether we need to codify the elections into law, I don't know if we need to do that. It's just good organizational practice. And I understand where you're coming from here. I do want to assure you, I belong to the Guam Medical Society, the older organization. And despite COVID, we have continued with elections and have continued the transition of leadership over time. So we've never had a lapse in this. So perhaps this is just good organizational practice to emphasize across the board. In terms of cutting the term to 3 years, I mean 3, 4 years, I don't, personally, I don't see any big issues with that. The only reason I believe it was initially 4 years is because that's the recommendation of the FSMB in this policy statement. And if you would like, I can send you a copy of that policy paper. And having 2 consecutive full terms instead of 3, again, I see the value of bringing in newer members so that we are educating a larger critical mass of physicians in terms of regulatory functions. The only caveat I would say is it's important to ensure that you don't start with a completely new set of board members at any one time, because there is a steep learning curve and it does take time. And I've been here for 2.5 years. I'm still learning, and I do my best, but I'll be the first to admit I'm not perfect, and there is a lot to learn. There is a lot to take in. So those would be my comments. I think if we want to really change and speed up the process of getting justice, and I do want to thank Senator Brown, because you really went to the heart of it. The issue here is the trust between patient and doctor. That's a sacred trust, and you're absolutely right. This is what is at the heart of all of these legislative changes, is this issue of trust between the medical community and the community. And so I would welcome having another community member on the board. But if we really want to change, I think, and to see faster resolution of cases, I would recommend, number one, we need a certain type of member on the board that I think we don't have, and that is a physician with expertise in substance abuse and mental health to help us address those issues of physician impairment. I think that's very important. We also should consider having a DO, a doctor of osteopathy, as part of the board. There are 2 types of physicians that we license in Guam. One is the MD, the doctor of medicine, but there's also the DO, the doctor of osteopathy. And while their training requirements overlap a lot, there are still some things that are specific to the DO side of medicine, and it's important to have representation on the board for that as well. I will go back to the importance of having dedicated full-time investigators and hearing officers who are there full-time throughout the year for the board, so we can address especially the very serious cases that go beyond medical issues. And also really supporting our HPLO office, who are doing a tremendous job, but are also tasked to oversee the work of the other 8 boards. And so any support that they could get, I think, would be really good. And I take my hat off to them for doing the work that they're doing. I think that's all I have. I do want to mention that back in 1993, nearly 30 years ago, the U.S. Department of Health and Human Services, Office of the Inspector General, they issued a paper where they recommended how state medical boards can produce timely negotiations and prosecution. So 30 years ago, they already said this, and I'm quoting verbatim. Number 1, have attorneys and hearing officers on staff. Number 2, have attorneys dedicated to the medical board cases. And number 3, train hearing officers to hear medical board cases. And the FSMB recommends either having them on staff or perhaps reverting back to that arrangement where the AG provides that sort of legal support. But whichever way we do it, I think this is the critical component to seeing faster action and resolution on the cases, and will, I think, help to perhaps start that process, a difficult one, undoubtedly, of starting to build back the trust between our community and the medical profession. Thank you, Madam Speaker.
Thank you very much, Dr. David. Ostropathy, O-S-T-R-O. Okay, thank you very much. And I think I agree with you on all counts, but we'll discuss later. Mr. Flores.
I'm I'm going to start off by congratulating whoever's in charge of the air conditioning in here. Okay. I had mixed reactions to the bill, including the Guam Medical Association and Medical Society in making suggestions for GBME members, though non-binding on the governor, seem fine. It would help in the recruitment of possible GBM members in the future. However, I don't know how much time they have to meet to make those recommendations, but I'm sure they can answer that for you. Reducing the number of physicians from 6 to 5, in my mind, is a terrible idea. Ask yourself, why are we required to have any physicians on the board in the first place? Is it because they understand medical complaints better than lay people do any day of the week? And I'm testament to that. They currently perform most of the investigations because of that. Reducing their number to 5 will simply increase the investigative workload for the remaining 5 doctors. Also, again, it begs the question, why? Is there something harmful about having physicians on GBME? Absolutely not. But I will go to what Dr. David just said. Perhaps it's good to bring in a public member and expand the size of the board so we don't lose the physician's expertise in it. That's all. Similarly, reducing the term limits from 3 to 2. I don't have any problem with going to the 3-year terms. Would not serve the public well. Would exacerbate the issue of the difficulty of finding physicians willing to serve. As for the public member, it would also allow that person to understand and contribute longer on the board, because there is, as Dr. David said, after a while there's some institutional knowledge in there that goes a long way. In closing, as we've been talking today, there's the reputation or just the feeling in the air that something's wrong with GBME. And as you said, Senator Brown, nobody's perfect, and we all don't get it right all the time. But the idea that there is a conflict of interest or special interest groups, David, that's absolutely wrong. There is not. If you accuse a physician of working with interest groups, working through with conflicts of interest, it's not the same as it's a physician. They're dealing with the medical issues on our island. And a physician to do something like that, it's almost, if he or she was doing it, that's almost criminal. And because you're leading to the ruining of our medical care on island. And I can tell you the physicians on our board, the ones I've worked with, current members and previous members, they don't fall into that category. They are all and have been really straight shooters. And we have a case right now that Dr. Berg has recused himself completely, and just because a perceived conflict of interest. And it's not the first time that's happened with one of our physicians. Now, if I may I be excused? I have to go back to work.
Sure, thank you. Oh, Mr. Flores, any questions for Mr. Flores, colleagues? No, I want to thank you, though, for the institutional knowledge comment and all your comments, but on that one, I'm trying to protect that by keeping the staggered terms. So there are staggered terms, supposedly, since the start, and I'm not trying to upset those. Those should continue. So
yeah, I think those, maybe 3 terms is kind of moot anyway. I don't know anybody who wants to serve on this board for that long, because this is a difficult board to work on, and it is difficult to recruit new members. And when Governor Cal asked me to be on the board, he said, it's been empty for years. Would you do it? Well, I'll use my governor. I'll do it for you, Gov. And well, I didn't think I'd be on this long.
Thank you very much for your service on the board, Jesus Masi, Mr. Flores.
And good luck to everybody in the election.
Thank you for being here.
Especially you Republicans.
Thank you for being here today. Yes, so on that, okay, wait, Dr. David. Questions for Dr. David? Senator Dueñas?
Yeah, I just think this can be probably resolved at our level. The speaker will address this, but I see what you're saying on going upwards. The thing is that will give us an even number. Maybe we'd have to address the resolution of tie vote on matters, but do you have an observation I know you served on a number of boards, Dr. David.
You know, Senator, what happens is that one board member is assigned as investigator for the case. So that investigating board member cannot be part of the group that makes a decision, just to have that separation. So in fact, if you go to 8 or to an even number, that one person who who's investigating will be taken out of that, and you end up with the
So
odd
they'd
numbers
automatically
of-
be a non-voting?
Yes.
Okay.
Yeah.
That seems to be maybe probably one of the more reasonable approaches. I'll see how the committee work goes. Thank you for your attendance.
Thank you, Senator Drain. Senator Perez?
I just want to thank you, Dr. David, for your presentation today and all the research. So,
Thank you.
Yes, we needed that. I wanted to know. So 60% clinical care and the others.
an-
So
as
that's
an
very
estimate.
helpful. Thank you.
Yeah, as an estimate.
Senator Brown?
Yeah.
Thank you, Dr. DeVitt.
Thank you so much. And
Thank you for all your work on the board. Can you please find out why HPLO did not show up today? And I hear they're transferring employees again around, and I don't understand that. I think the HPLO has good employees and need to keep them while we're actually functioning to clear out cases. If you could look into that. Thank you. All right. Ms. Espinosa, on Bill 318.
Yes. Yes, I am in full support of Bill 318, and my testimony will be fairly short. I was very concerned when they brought up having an even number of board members. You always need to have the odd number to get a majority vote. And I don't know if it should be mandated that a line item in here that they need to have in their policy and procedures to reflect an odd number of voters, the way she was explaining. I don't know about that issue, but we need to ensure that it's going to be an odd number who will be voting somehow, somewhere in their policy or procedures. On subsection 5, where it talks about terms, 2 consecutive full terms, and beginning this year will be 3 years, I have no problem with that. But on the last line, it says, and a former member shall again be eligible for appointment after a lapse of 1 or more years. I do not agree that 1 year is sufficient. I have been a member of the board 4 different, granted they're not medical, but 4 different boards in since I had my son. And it should be a full-term lapse. There will be those individuals who tend to, uncommon, but there are those individuals that feel entitled and they want to dominate the way the meetings go. And I think when their term, after 2 terms is up, they should retire for 3 years, and if they feel like running again, make their availability be, the governor to be aware that they're available to be reappointed. But I think it should be a full term of, to take a break there. Sometimes, it can hurt the way the board moves, but I feel with my experience, it's better to let them go for a full term of 3 years, beginning this according to this bill suggestion. And my final suggestion is totally off, but because I have been a member of 4 different boards, I really feel that this kind of board should be an elected position. And although we will be unable to do it this term, but given all of you that will be re-elected, that next year when you're all back, that revisit it and turn it into an elected position. Because board members reflect the governor's choices, and there is, my experience, there is still kind of like too much loyalty, attachment, and they follow the big boss's preferences, and it's better if they're just elected. And as I said, it's impossible to do it this year, but maybe in the future we could reconsider and make it an elected rather than an appointed position. Thank you for your time.
Thank you, Ms. Lastimosa, and for sharing your experience on those boards. Very much appreciated. Mr. Marquardt.
Hi, good afternoon. My name is Robin Marquardt. I am in favor of the bill, and I wish the board members were still here. They're not here. Why are they not here? They should hear all this. What came to mind is contrast. We have the richest guy on the board. I was wondering why he was on the board, and that came to me. He's not the doctor. So contrast would be, you have the richest, so who's the poorest? Those guys on the street asking for dollars, right? Do you want them on the medical board? Perhaps. Maybe they'll stick around and wait for a meeting long enough to hear everybody out because they got nothing else to do. Maybe they'll be doing their job as not doctors to help the public, the consumers, the patients, because they got nothing else to do. No, these are the poorest, right? So maybe not the poorest, because maybe they have some mental illnesses that would they won't be able to just focus and do the job. But nonetheless, I'm showing a contrast. 3, 4, 5, 6 years, I was just getting confused because I heard there was people on the board for 20 years, so the less the better, I guess, 3 years. The staggered terms makes a lot of sense. I'm not sure exactly how all that's working, but certainly better than someone on the board forever, emboldened to the governor or with ties to industries that are the conglomerates of power. Getting back to the poorest versus the richest. And I wanted to say one more thing that I wish the board was here to hear. I just want to close with this because I kept hearing my mom saying it as she taught me. When you grow up, you're going to be an attorney. 7 or 8 years old when she's telling me this. My mom's name's out there on the list of survivors. Blandina, LG, Gogui, Marquardt. I'm happy to see that. But she's not here with me in her physical, okay? Any amount of money I would not want versus my mom being alive, and just to put that into quantified perspective, $2 billion versus my mom being alive, I would take my mom being alive. So it's important, this work that you're doing, the legislation that you're writing, because there are all the doctors on the board backing each other up. It doesn't seem that they're looking at a case or any case or all cases objectively. And the fact that they're taking so long to decide just shows that they don't, it's not high on their priority list. So these things that are being written, your legislations, I believe will help. I certainly feel will help. Or Adzuda, will Kokua, right? So I think that's it. Unless anyone has any questions for me.
Mr. Marquardt, I do hope
Bien Verbetsu.
they help. That's of course what I'm hoping. I hope our oversight hearings have helped to move these cases along and that our continual following up. Any questions by my colleagues for any members of the panel? Senator Duenas, Senator Perez.
No questions, but I just want to thank Ms. Espinosa, Mr. Lubowski, Mr. Marquardt for being here today and taking the time out of your day to provide testimony. Thank you.
Senator Brown? Yes, Mr. Lubowski.
how to use the mic. This is not really related to 318, but it is related. We keep coming back to the same issue about medical malpractice, the MMMAA. Ultimately, that's at the root. It's my opinion, sadly to say, that I don't think that issue is ever going to be resolved here. I think that issue will be resolved when you get some people together, rational doctors, rational consumers, sitting down and talking about it. Yes, the legislation has done so much, and we hope for change in the law. But you can see there's still the far left and the far right, and I'm not talking about politics, that the only way it's going to work is for people to sit down and talk. We've been at hearings here. We've heard people yelling. Is my mic on?
Can you please make his mic louder?
We've been here. We've heard people yelling at the speaker. It was let me use the expression, it was a freak show during the 11236 hearings. I'm not going to get into all that. The videos are out there. I've never seen anything like that in my life. It caused me stress. I have a lot of reasons to yell at people, but I never do. And I won't. But the only way we're going to get past all these small bills, which are great because things get done slowly, but they get done, is to get people who are rational. Doctors, there are many doctors, I know many doctors, I've been here forever, I know many doctors on Guam say, I agree with you, I agree with you, I agree with you. One of my doctors just said with me, he said, I agree, but don't ever tell anybody. They're afraid to speak up. They're afraid of the cabal, so to speak. They're afraid of what will happen to them. If we can get doctors who can sit down with consumers and not yell at them, because I'm not going to sit in a room. I wouldn't be in a room with people yelling at me. You guys have to put up with it. I wouldn't want to do it. And we know what I'm saying. That would be a step forward to come up with ideas, how to negotiate and so forth. No doubt, even if that group agreed afterwards, there would be the extremists who would say, oh, no, we can't do that, we can't do that. But to move all these issues together, someone's got to talk who can sit, medical and consumer, and can sit and really figure things out and talk about it and then try to bring it to the other doctors with the help of the legislature. Otherwise, we're going to be doing, we did this in the 35th, we're at the 36th, and no doubt we'll be, hopefully everybody's here, we'll be at the 37th doing the same thing. And all I'm saying is, it's about, I support the bill, and I support 317 and 319, but to move all this stuff forward and to protect people, is something has to break. There's people dying. Something has to break. And when people say, oh no, he's angry, he doesn't know what he's talking about, he lost his kid. Every day, no, I would say now 3 times a week, I hear from somebody. This is what happened, who should I call? This is what happened. We all know the story about Arlene, the medic, the military, and everything that happened to her. I heard from her. I heard from people that know her. And what happened at GMH. There was a baby recently at GMH. 11-month-old, beautiful baby, rushed up from Sagwa because she needed a C-section. Doctor wasn't available, and some doctor said, we'll natural deliver. The baby got stuck. The doctor tried to push the baby. This is all true. You can ask Dr. Badell. Tried to push the baby back in. Baby died. 11-pound baby. That's a pretty big kid. 11-pound baby. They call me. What should we do? What should we do? I hear this all the time. Maybe I'm known for this. I don't know. And I don't mind. Maybe it's part of my legacy for my son. But without talking about these things keep on going on and on. Mr. Flores said, oh, the board members are all like this, like this. It's the public perception. It doesn't matter what an individual says. The public perception is that the board members are biased. And there's people that have come forward and have said it over and over and over again. And okay, I respect what he has to say. I don't agree with it. But again, these laws are great. 318 is great. But the only way we're going to get to the next step is to somehow get some group of doctors together with consumers and maybe members of the legislature and just have a talk. Just sit around and not so formal like this and talk about, okay, what do you think? Because there's many doctors on Guam, and I think you all know this that agree. There's many nurses at GMH that have come forward to me, see me, walked up to me and said, that you're right, there has to be change. We can't say it. You say it. Well, you're right. There's people dying. There has to be change. So I don't know what I'm actually saying to you right now, except I'm just saying we'll be here over and over again. I do this for one reason, to hopefully save a life. Because tomorrow it can be one of your relatives or your family or your or friends or whatever. Every day somebody's at risk. It's not about my son. He brought me to the table. But it's about the hundreds of stories, literally hundreds of stories I hear all the time. Email, messages, people know how to reach me on Facebook. What should we do? What should we do? So anyways, all I'm saying is that somehow we have to come together. Well, these small bills are great, and find some way for people to talk to and not be yelled at. I fear sitting in the same room with some doctors. I fear seeing them on the street because they go like this to me. And so forth. My family was denied medical treatment. One of my children. No, we don't have room for you. Anyways, thank you for listening. Thank you for listening.
I very much appreciate your testimony, Mr. Lebowski. It's not difficult. I mean, it's not easy. I'm sorry. It's difficult to continue to even question some members of the medical community. I am sincerely hoping it's not all of them, that they don't all think like that, and that they think independently, and that they see for themselves the community's response to cases lingering for years and years and years without resolve, that they see for themselves the community's response to being precluded from suing for malpractice. No one else in the nation has that type of a law. No one else has the most expensive arbitration process in the nation. Only Guam. And so many of the doctors, just like you have said, have come up to me with very reasonable responses, but the public ones sometimes are not. Some of them are, and I have taken all their considerations into account. That's why I'm here today with some of these bills. So many of these doctors told us, stay out of the medical malpractice, get on those boards. And now we're on the boards, and I get letters from the Guam Medical Society and Guam Medical Association saying, this is yet another step by the legislature attacking the physicians in the community and weakening the already fragile healthcare system in Guam. So, like I said, we also have ourselves and colleagues been threatened with not receiving medical care. And of course, my voice is changing because that is very unbelievable to me up to now. And painful and outright, I think, immoral. But I can't regulate that. There are certain things that the legislature is responsible for regulating. These laws exist. We are really just tweaking them. It is patients' right to sue for malpractice. We are just trying to tweak that law so that it's not so inexpensive or so expensive that no one can do it. And we're trying to tweak this law so that the cases move. And we've had oversight hearings for that purpose as well. And so that's the best news I've heard today, is that the cases are actually moving. I'm disappointed because they told me they had changed and they were informing all the patients, and now I understand that's not the case. And this is not necessarily my job to follow up with them whether they're doing their job, but the legislature is the last recourse. It's like they've gone to the hospitals and the clinics and the board. They've gone to lawyers and they get refused, and then they come to us. And so we don't always agree, but I'm confident I speak for all of the senators when we're trying to find ways, and we are going to continue to do that. And I just hope that some of these can be found to be reasonable efforts by the physicians, and that I agree, and they have amongst themselves talked to each other, and they've tried to come up with reasonable alternatives for us to look at. And we are doing that, and we will do that. I will always do that. And we will look at everything, but of course, in those rooms, no patients were represented, no victims, and we have to balance those interests as well. And so that's what we're trying to do. So I appreciate all of you and the testimony that you provide in these hearings. It's very important for us. I think it's very important in our role. I mean, we can't just hear one side. We have to hear all sides, no matter how painful, no matter how, even the yelling. I don't appreciate yelling either, but I don't, you know, if that's the only way they're going to testify, I'll take it, because I'm not going to be accused of not hearing them. I am trying to hear everybody. Mr. Marquardt, you have your hand up. You're trying to say something.
Thank you.
Mr. Marquardt? Oh, Ms. Lastimosa? Lastimosa.
The other part about having boards that I've come is I really don't like the idea. If they're going to be a chairperson, if they elect their chairperson, if they are going to be chairperson for the full 3 years, I don't like that they are going to continue. It's safer to mandate that they can only be a chairperson for one full term. It all feels kind of fixed when you get appointed by the governor, and then so you get a whole set of people that are the majority, and they'll vote for one person, and the movement goes this way. And as opposed to, okay, at the end of the third year, at least if you have you're mandated to choose another, it'll be different. There'll be a difference. However slightly, it will benefit the board when there's a different person. In rare cases, you might lose, having a really good chairperson, but if you have somebody different, it's safer, and I think it would be more productive, and we'll probably avoid what, Mr. Lebowski has been
Thank you, Ms. Espinosa.
pointing out.
Thank you very much. Mr. Marquardt, we'll wrap it up.
Thank you. Thank you. Just one more thing. Just one more thing noteworthy. I mentioned earlier that my dad died and that my mom died. So when we were informed that my dad was terminal, he lasted 3 weeks at Navy Hospital. Compared to where my mom went, I took my mom, I didn't take her to JMH because I was afraid, the rumors. I took her to the new hospital, GRMC, thinking she was going to get fixed. She died in 3 or 4 days. So I'm complaining here because I didn't expect her to die at all. Whereas the Navy hospital, we knew he was going to die in about 3 weeks. Well, we knew he was going to die, and he lasted 3 weeks. Sorry, excuse me. He lasted 3 weeks. There's no complaint there. The Navy hospital actually let my dad come home on Thursday. The next day, which happened to be Good Friday, he was pulling out his tubes, and what do I do as his first son or his only son or his firstborn son? I have a sister and an adopted brother. Call the ambulance. My dad was taken to GRMC, where he died 2 or 3 days later on Sunday, Easter Sunday. No complaints there because we already expected it. But in comparison, I took him to GRMC, not GMH, because of the fear factor, but she died anyway.
Thank you very much, Mr. Marquardt, and my condolences.
Thank you.
All right, colleagues, we'll conclude. Thank you. So this hearing is now concluded on Bill number 318. The time is 4:18 p.m. Thank you very much. Sidus Masi. We have one final bill on our agenda. That's Bill 319, introduced by myself, Therese, Terlaje, and Terlaje. It's relative to implementing the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021 into Guam law. The act voids pre-dispute arbitration clauses in cases involving sexual sexual misconduct allegations. This critical legislation was supported by a coalition of survivors of sexual harassment or assault and their allies, including the including the National Center on Domestic and Sexual Violence, the National Coalition Against Domestic Violence, the National Domestic Violence Hotline, the National Network to End Domestic Violence, RAINN, and the Sexual Violence Prevention Association, among others. It's also supported by public interest and advocacy organizations such as Public Citizen and the American Association of Justice. Federal lawmakers inserted the Ending Forced Arbitration Act within the Federal Arbitration Act, thus the Ending Forced Arbitration Act serves as an exception, I think, to that Federal Arbitration Act. As some may know, Guam implemented its own arbitration procedures in Title VII of the Guam Code Annotated and did not adopt the Federal Arbitration Act, which is found in Title IX, U.S.C. Chapter 1. So while courts have found that the FAA applies to the states, we have not found a definition of states in the FAA to include Guam, as it does in other federal statutes, such as the Uniform Child Custody Jurisdiction Act. And we have inquired with our counsel and Attorney General's office, I believe, and that is the feedback we have received so far from our own counsel, is that it does not look like it applies to Guam. So that's why this bill was introduced, is to make this apply to Guam. So we've invited the judiciary. That's my introduction of the bill. We've invited the judiciary, the Department of Administration, Guam Civil Service Commission, HPLO, Guam Board of Medical Examiners, Bar Associations, SHRM, Society of Human Resource Professionals, Guam Chamber of Commerce, Guam Women's Chamber, Guam Coalition Against Sexual Assault and Violence, Victims Advocating Reaching Out Vero. And we did receive written testimony from David Lebowski. Thank you, Mr. Lebowski. And BBMR has said that it poses no fiscal impact upon any of the funds of the government. So, Mr. Marquardt, would you like to present testimony on this bill?
I wasn't ready for this one. I only got information for the first three bills.
Okay.
I mean, first two bills.
Yes.
Can you summarize it?
I just did. It's trying to mirror a federal act that right now across the nation there are some arbitration agreements where every dispute has to be resolved by arbitration. But this would make an exception that despite any mandatory arbitration agreements in any setting, not just medical, but any setting, that this would make an exception where there is sexual assault and sexual harassment. Those do not need to be settled through arbitration. That's what this bill would do, is make an exception.
Can I
Call,
get one for 18?
Senator Perez, anything on this bill? Senator Brown? Okay.
Ending forced arbitration. So right now there is arbitration?
Right now, arbitration is authorized on Guam, yes.
So you want to end that?
No, not at all. Not at all. All this does is I'm trying to extend an exception on Guam, to Guam, that in the case of sexual assault, you do not need to follow mandatory arbitration in any contract, in your employment contracts, in your any other types of contracts that you may be entered into on Guam, that the arbitration dispute, even rental contracts, if it's got to do with sexual assault, they do not have to proceed through arbitration. So this would be doing this by statute, which Congress did. And so we, while we are waiting for any other confirmation that we are included, it looks like we are not, so I'm trying to extend it to Guam. That's it. So if it's okay with you, Mr. Marquardt,
I would provide testimony, except that I have no personal experience or issue.
All right, and thank you. Thank you very much for your testimony today.
Likewise.
I appreciate it. All right, so my colleagues have no further statements or questions, and I have nothing further to say on this bill either, except that I hope that my colleagues do support its passage. We will now call the hearing for Bill 319 duly heard. The committee will remain open for submission of additional written testimony on Bills 317, 318, and 319 for the next 10 working days following this hearing. Testimony can be sent via email to Senator Terlaje @gmail.com or hand-delivered to my office at the Guam Congress Building. I want to thank all those who sent in written testimony who I read earlier on the bills. I didn't have time to read them all today, my apologies, but they will be posted on our website and they will be made part of the committee reports. And we just received another one from Jesse Lujan in support. All the testimonies were in support of Bills 317 and 318, except for the written testimony from the Guam Medical Society and Guam Medical Association was against Bill 317. Thank you again, and this hearing is adjourned. It's 4:25 p.m. Thank you.